good evening, and welcome back to latest case analysis series by LawSikho. This is Monica Rahar, and for today's discussion, we have taken up a decision by the Honorable High Court of Delhi, which is dated 16th of December 2020. The name of the case is Bibha Pandey versus Punjab National Bank and others. It is a single judge bench decision, and the bench consisted of Honorable Justice Pratibha M. Singh. Now let's proceed and understand the issue of law. So the court was to decide whether comments made by the ICC, which is the Internal Complaints Committee, about the personal conduct of parties when allegations under the POSH Act are not sustained are within the jurisdiction of the ICC, which is laid down under Section 13, subsection 2 of the POSH Act. So simply, the issue of law before the court was that whenever the ICC receives any complaint and it comes to the conclusion that the complaint is not sustained and no sexual harassment was meted against the woman, then can the complaints committee make make comments about the personal conduct of the parties? So will it come under the jurisdiction of the ICC or will it not come under the jurisdiction of the ICC? So now let's proceed and understand the brief facts of the matter. So, a complaint was made under the POSH Act, which is the Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act of 2013. The petitioner filed complaint under the POSH Act against respondent number 3. Respondent number 3 is the general manager of respondent number 1, and respondent number 1 is the Punjab National Bank. And this is the branches of Mumbai. So the complaint was referred to the ICC, which is constituted by the bank. And now let's look at the conclusion of the ICC. So the ICC concluded that there was a consensual relationship between the petitioner and the respondent number 2. They were having physical relationship and with mutual consent. So relationship between the petitioner and the respondent number 2 was based on their personal grounds with mutual consent, and the allegations of sexual harassment of an allegation of harassment, both sexual, mental, or emotional, they cannot be sustained, and the complaint against R3 was therefore rejected. Now, after having concluded this, that the complaint is not sustained, the ICC made certain observations on 15th of March 2017. And the observations were that the party's behavior, it was inappropriate and unbecoming of officers or employees of the bank. Both the parties behaved or acted in a manner which is not befitting to the post they hold, and they did not act according to the decorum of the post that they hold. And therefore, the ICC recommended competent authority to take suitable actions against the petitioner and the respondent number 3. And in pursuance to these recommendations, a charge sheet was served upon the petitioner, and the charge sheet was served upon on 15th of April 2017, a month later, after these observations were made. And this particular charge sheet, it was served under Regulation 6 of the PNB, Punjab National Bank, Officer Employees Discipline and Appeal Regulation of 1977, on two grounds. The first, obviously, being the ICC recommendations, and the second, various other communications which was extracted between these two parties. And therefore, the present petition was filed by the petitioner, the woman, challenging two things. The first, the ICC recommendation for taking suitable action against the petitioner and the respondent number 3. And second, the action by the PNB, which is filing of charge sheet and serving it upon the petitioner pursuant to this recommendation. Then on 19th of April 2017, single judge bench of the Delhi High Court entertained the present petition and stayed till further hearing the ICC recommendation and the consequent charge sheet. And during the pendency of this particular stay order and the present petition itself, petitioner became eligible to be considered for promotion. And she contended that her promotion was held up in view of the pendency of the present petition. And therefore, the court directed the bank to independently consider petition's candidature for promotion, but the same would not be given effect to and be kept in a sealed cover. So this was also directed that you do not give effect to the promotion. You consider the candidature of the petitioner irrespective of the pendency of the present matter and the charge sheet. And once you've done that, You do not give effect to the promotion and keep it in a sealed cover. And due to lockdown, the matter could not be heard thereafter. Then the bank recorded the performance of the petitioner, and in the meanwhile, PNP also placed on record in sealed cover the relative performance of the petitioner and her prospect for promotion independent of the charge sheet. And the petitioner indeed became eligible for promotion independent of the charge sheet, which we'll look up later on. Now let's proceed and understand the cases of the parties. First, let's take up the case of the petitioner, followed by the case of the bank. So the petitioner contended that upon rejection of the petitioner's complaint under the POSH Act, the ICC can merely close the inquiry for the case not having been made out against respondent number 3. However, the ICC recommended that action be taken against this due to the alleged unbecoming conduct. And such a recommendation, it is contrary to Section 13, subsection 2 of the Act. And insofar as the conclusion of the ICC are concerned, petitioner did not wish to challenge it. And the conclusion was that this allegation of sexual harassment, it is not sustained. So this conclusion, petitioner did not wish to challenge for personal reasons, so long as the recommendation made by the ICC were set aside by this court. On the other hand, the bank stated that the ICC concluded that both parties were in a consensual relationship, and on the basis of this conclusion only, the bank acted upon. And in terms of the bank rules, whenever there are pending disciplinary proceedings, bank is bound to keep promotion in a sealed cover, which is promotion policy of the bank. And it is in view of this policy that the petitioner's result were kept in a sealed cover. Now let's proceed and understand the reasoning and decision of the court. So first let's take up the observation with respect to the conclusion arrived at by the ICC. So the court stated that ICC conclusion, it had two parts. The first part, it concluded that the allegations leveled by the petitioner under the POSH Act, they were not sustained, and they were also not substantiated by concrete proof, and the complaint was not made out. Second part, ICC commented on conduct of the petitioner and the respondent, and it also recommended that the bank may take suitable action. Now let's look at the observation with respect to whether the recommendation of the ICC fell within Section 13 of the POSH Act. So Section 13 contemplates various situations which are relevant to an inquiry report. So whenever the ICC conducts an inquiry, the inquiry report comes in. So what is to be done with this report? This is what is provided under Section 13. So insofar as the ICC is concerned, there are two situations which are contemplated under Section 13, subsection 2 and 3. So before we proceed, I'd like to give a brief introduction of what an ICC is. So under these particular POSH Act, which is the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act, under this particular act, obviously it is intended to provide a safe environment for women to work at a workplace. It defines various terms like what is a workplace, what is sexual harassment, and once having done that, this act also provide mechanism of grievance redressal. There are two such institutions which are provided. The first being the internal complaints committee, and there is also a local complaints committee. So every workplace is required to have an internal complaints committee, and there is a certain threshold. So a workplace having more than 10 employees is required to have an ICC, and the task of the ICC is to hear whenever any allegation of sexual harassment is made, it is made to the ICC. The composition of the same is also provided in the act itself, which is that there has to be a member of an NGO working in this particular field, there has to be a senior woman from the same office, and there is a certain other composition layer given in the act. So the ICC is duty bound to inquire the particular complaint which is before it, and once it does that, it reaches a conclusion that whether a particular allegation is made out or not. So when it is made out, what is to be done? When it is not made out, what is to be done? That is provided for under Section 13. So Section 13, subsection 2, it provides that when the ICC conclude that the allegation against the respondent, they were not proved, then it is mandatory to recommend to the employer that no action is required to be taken. So once the allegation is not proved, ICC is duty bound. There is a use of the word shall, that ICC shall recommend to the employer that no action is required to be taken. And then in section 13, subsection 3, it provides that when the ICC come to the conclusion that the allegations were in fact sustained and made out, then it will recommend to the employer that the employer should take action for sexual harassment as a misconduct in accordance with service rule. So government employees, for them, there are service rules which are applicable to them, which provides that whenever sexual harassment allegation is proved, then it will be treated as misconduct, and there are certain liabilities which are attached to a misconduct. And then the employer can deduct appropriate sum from the respondent's salary and wages to pay the aggrieved woman or her legal representative. And also, wherever there are no service rules made or applicable, then any rules which govern the workplace. And then there can be also an order for deducting appropriate sum from the respondent's salary. And in case the respondent is unable to deduce such sum from the respondent, the employer is unable to do so, then it may be directed to the respondent to pay it to the aggrieved woman directly. And if the respondent does not do that also, then the ICC may forward its order for recovery as an arrear of land revenue to the concerned district officer, and the money can be deducted from that route. Now, if the allegation of sexual harassment or any other form of harassment as contemplated under the POSH Act, they were not proved before the ICC, then at maximum what the ICC can do is it can only recommend the employer to not take any action in the particular matter. Now let's look at the observation of the ICC with respect to the scope, observation of the court with respect to the scope of the ICC recommendation in the present case. So the court stated that ICC went beyond its statutory mandate as recognized under Section 13, subsection 2, giving observations about conduct of parties in terms of have indulged in inappropriate or unbecoming conduct and indiscipline. So, and recommending competent authority to take suitable action against them. This is way beyond the jurisdiction of the ICC. It was not within the scheme of the POSH Act that while holding that no action has to be taken and the complaint is to be rejected, the ICC can direct for suitable action on the ground that the parties have indulged in inappropriate conduct. So, such a determination and consequential recommendation, it is beyond jurisdiction and it is not within the scheme of the POSH Act. And then let's look at the observations with respect to moral policing done by the ICC. So the court stated that moral policing is not the job of the management or that of the ICC. Any consensual relationship among adults would not be the concern of the management or the ICC so long as the said relationship does not affect the working and discipline of the organization and it is not contrary to the rules or the code of conduct binding on the said employees. So long as it is not contrary to any rules or conduct which is binding on the said employee, such a remark on the personal conduct of the parties who have indulged in consensual relationship with each other, it is not the mandate of the ICC and also the Act. And such moral policing, it should not be there. Then the court stated it is only if a complaint is made of sexual harassment under the Act that the management can constitute the ICC to inquire into the same. The ICC cannot make comments on personal conduct of the parties, and the jurisdiction of ICC would be restricted to allegations of sexual harassment and whether a complaint is made out or not. Now let's understand what was held by the court in light of these observations. So the court held that the last paragraph of the ICC recommendation, which commented on the party's conduct and recommendation taking of action against the petitioner and the respondent number 3, they were for appropriate disciplinary conduct. So these were not tenable and this was liable to be set aside. The charge sheet drawn upon the petitioner, it was also quashed on the basis that one of the factors leading to the charge sheet was the ICC recommendation. And since the recommendations itself were not sustainable in eye of law, the so should not be the charge sheet. And therefore, the fact that the petitioner became eligible for promotion meant that PNB would offer her the promotion in accordance with her seniority, performance, and merit as per the applicable service rules, and the charge sheet would not be an obstacle or an obstruction in the petitioner's promotion. So that's all we have for this case analysis. Here you may find a list of abbreviations which are used in the note. You may refer to it. And thank you for being with us.